Hello, everyone. Hello, hello, hello. So excited to see you guys this evening. I'm a little early, so we'll just wait patiently for our guests. Hope everyone had a wonderful day today. We'll give it a few minutes and we will be right back. Good evening, good evening. We will get started in a few minutes when our guest arrives. Thank you guys for joining. Hello, everyone. Welcome. Glad you guys could join us tonight. Another great topic this evening. We have an estate planning attorney joining us in a few moments. So super excited. We can learn how to secure some of this wealth we're building. Hope you all had a good day today. I did confirm with Lillie and she will be here. So we'll just give her a few moments and then we'll jump right in and get started with the topic. We'll spend about 45 minutes with her. And I'll make sure you guys have her contact information and all of that, just in case you want to reach out directly. Hi, Felicia. I'm glad it's been a good day, dear. Thank you, Miss Patrice. Hi, Lily.
Hi, Tawana. Sorry, Tawana.
All right, dear. How are you?
And yourself?
Good, good. Good to see you again. Good to chat with you again. I know the community's excited.
Yes.
So thank you so much for taking time out of what I know is a busy schedule to come
You're
chat with
welcome.
us. Help us secure the bag. So thank
Yes,
you so
you are so welcome. Very welcome. How have you been?
I can't complain. Life is lifing, but it's all right.
It's
It's
Marie.
ah, it is okay. I
So tell
see
me,
the
how would you like the flow to take place today? Is this a question and answer, or you're asking me questions and I'm responding?
Yes, so I think we'll definitely be getting some questions from the community members as they come in. So would love to be able to answer their questions directly. Want to also make sure they get your contact information, just so that they can reach out if they have any questions personally in this, and they're in the states that you're licensed in, and we'll talk about that. I really want you to talk to us about, the overall importance of estate planning, obviously talk about what it is, what it entails, right? All the
Right.
we hear that term, but I don't know that many of us really understand what does that really mean, right?
Mhm.
And then to talk about the importance of it. If we could even get some high level steps on where to begin,
Got
and I want the community to walk away with a good idea of what their next step should be, right? For
Right.
those who have assets that they want to secure, or who are looking to get assets that they want to make sure they secure once
Right.
they have them. I want them to walk away feeling like they have the good outline. It's kind of like writing a paper. When you do the outline first, that's what I really want them to walk away with is the outline on what they need to do to really secure the wealth that they are building or have built.
Right. Perfect. Okay.
But
Have
let's
a
start
good.
by introducing yourself, like, to the community. They know who I am.
Of course, I'll do that and I'll flow through. Do you guys have a policy where we answer questions as we're going along, or we hold questions to the end?
I think that's however you prefer it. We've done some of everything. So how do you prefer to go through it?
I can answer questions during.
Okay.
That way it's live on the person's mind and I can get right to it right then and there, and then go back and forth if their question is unclear.
Okay.
And then I can read the chat, or if you want to interject with a question from the chat, that's fine too.
Yeah, I'll interject for you so you don't have to focus on the chat. And then also, if we get too much back and forth, we can actually bring them on where they can, we can kind of have live dialogue. So we
I
can
see.
allow them to talk. So that makes it a little easier in real time. We can have dialogue if they have really in-depth questions as well.
Excellent. Excellent. Thank you.
Nope. Thank you.
Of course. They are rolling in here. I see we
They
have
are.
14
They
attendees.
are. They'll
Is my
keep
background quiet? Are you okay?
Yeah, you're fine. You're good. I see you clearly. I can hear you.
Okay, wonderful.
Hi, Miss Mavis. Hi, Tawana. Welcome.
And this is an hour session, Tawana?
We go about 45 minutes to an hour.
Okay,
We want to be very respectful of your time.
okay, thank you.
And we can get started whenever you are ready.
Okay, great. Whenever you're ready, I'm ready.
Let's do it. Let's do it. Let's start with introducing you to the community.
Okay. Are we on?
We're on.
Oh, I didn't know that. I thought it was just you and I. We were being brought into the main room.
No, we're here. We're all here.
Wonderful. Good evening, everyone. Thank you, Tawana and team, for inviting me to this wonderful space. I had not heard about the 10K project until Ms. Tawana and I were introduced through a mutual colleague, and I Googled it and did some research, and I thought, wow, this is amazing. This is great. I'm really impressed that persons are taking this level of initiative to increase their financial education, awareness, their financial power. So I'm happy to share my information and resources in furtherance of your goals. So thank you all for being here. My name is Lillie Nkenchor. The work that I do is basically estate and business planning, which means I help people figure out what happens to their assets and their loved ones when they're no longer here. I have been doing this for 15 years. I love it. It's the only area of law that made sense to me. Estate planning to me is powerful because with the right paperwork, you can take care of yourself. You can take care of your family. You can take care of the next generation and the generation thereafter. And I have always found that discipline to be the most empowering and engaging of all the disciplines. In law school, I was just going through the classes like next, got to estate planning and tax law planning. And I thought, oh, it's about time. I was wondering where my tuition was going. So here we are. So I'm here to discuss estate planning, the overall umbrella, some basic documents that I think everyone should have, some forms of estate planning that you all can take on your own. You don't need me, you don't need any attorney. There are things that you all can do to get the ball rolling. And then of course, answer any questions you all may have. So thank you again, Ms. Tawana, for introducing me or allowing me to be here and introduce myself.
Thank you.
You're welcome. So we will start with what is estate planning. It comes up so often. And because I've been living and breathing this discipline, I feel like it's as easy as 1 + 1 is 2, but I have to pause and recognize, no, it's not. This is not water cooler talk. Most persons aren't exposed to this until some tragic family event occurs, and then all of a sudden we're forced to know what estate planning is. And so I tell people all the time that estate planning is just the orderly distribution of your assets. Emphasis on the orderly, because if you don't have a plan, your assets will eventually be distributed, but it may be distributed in a very confusing, stressful way that actually costs you more money and decreases the legacy that you leave behind. So estate planning is just the orderly distribution of your assets, and the different types of documents, the wills, the trust, the healthcare proxies, the power of attorneys, those are all the different ways that you can make your estate plan effective. But estate plan is just the big umbrella that's all about how do I put together a plan that cares for my assets and cares for my people. So I always tell people, if you are someone who cares about the assets that you've accumulated and the people that you love, and you want to put a plan around those two things, then you're the perfect person for estate planning. Do not think that estate planning is only for wealthy people. And it's a very popular misconception because unfortunately, at least we here in Western culture, always talk about estate planning like it's for the wealthy people over there, the people who have the properties in the Hamptons and the Caribbean, the people who make $1 million a year. And so if we don't see ourselves in that definition, we say, oh, that doesn't apply to me. I don't need to do that. But I always tell people again, do not get caught up in the value of your assets. It only matters if you have assets that you care about and people that you care about. So my job and the job of any estate planning attorney is to sit down with you, hear what's important to you, and then suggest the right instrument to use to make your estate plan come to life. Does that make sense?
That makes perfect sense.
Wonderful, wonderful. So that's estate planning. And I love it a lot because, as I said earlier, it's very empowering. You get to have an influence. I never make it seem like you get to control everything, right? Where a lot of us are control freaks. I'm not naming myself, but some of us are control freaks, and we think that I can, plan my life down to the semicolon and down to the decimal point. You cannot, but you can use a really tight estate plan to influence the future. Influence the legacy. I don't like to go as far as saying controlling the legacy, because any of us who have children know that control is an illusion. we can bribe, we can chastise, we can
negotiate. Yeah.
yeah, we can negotiate, we can punish, but control is an illusion. But what you can do is have an influence. Just like your children are watching you, what you're saying and not doing, that's your influence. Your estate plan is another way to do that. So think of it as your ability to write the final chapter of your book. You have led a really beautiful life, ups and downs, ins and outs, and you have a right to close the final chapter on your terms. It doesn't have to just be left up in the air and let's hope that my children know what to do, or let's hope my spouse knows what to do. I always tell persons, death and money changes family dynamics very, very quickly. So all the Thanksgiving dinners and all the understandings that you think you had while you were alive, all of that goes out the window. Don't let there be a house that people want, or a piece of land that people want, or money that people want. All of a sudden, all of the warm and fuzzies and the birthdays and the family reunions, they can really be damaged. So not only is estate planning your opportunity to write your final chapter based on your terms and influence your legacy, it's also your opportunity to try to minimize the family drama. I always joke that when I went to undergrad, I told my mom that I wanted to be a psychiatrist, and she dissuaded me. Don't be a psychiatrist. That's not a good profession. I don't know what she meant by that. But now I call her up and say, I am a part-time psychiatrist because the family members are calling me. One's crying, one's screaming, another one's arguing, another one's emailing in all caps. I'm a part-time therapist, so I get to have two jobs in one, I guess. So let's get into the basic documents that I think everyone should have. We will start with the will. The will is your opportunity to say, this is who I am. These are my family members. Pay my debts, because, and we'll get back to this later, your debts don't disappear just because you're not here. Pay my debts, and then whatever is left, distribute it in this way. Tawana gets a third, Lillie gets a third, Michael gets a third, and we're done here. So the will acts like a crossing guard. If you've ever seen a crossing guard managing an area where the school children are crossing, their job is to stop the traffic, make sure the child gets to the other side of the street, and then they're done. They're not following the child to make sure that they're paying attention, that they ate, that they're not being bullied. That's not the crossing guard's job. So the job of the will is the same thing. The job of the will is to say, hold up. I know we like to come into the house and start taking things. So that was my favorite plate dish. That was my favorite set of plates. No, don't come in here and take anything yet. I have a set of instructions that I need to follow. I'm going to distribute everything accordingly. And then once everything is distributed to the beneficiaries, the job of the will is done. If that beneficiary takes their gift and turns into the next Oprah, fantastic. If that beneficiary takes their gift and wastes it in South Beach, Miami, that's their problem. Okay. The will is not following people around to make sure they're doing the right thing with their gift. So if you're the type of person who says, I just want to give Tawana her money. She's responsible. She's an adult. She doesn't have any crazy spending habits. I don't think she's married to someone who would take advantage of the money that I give her. I'm completely comfortable just giving her gift. Then you give the gift to Miss Tawana in the will and wrap it up. Okay. Back to the debts. I said it doesn't go away because it doesn't go away. I will clear up some myths. No one is personally responsible for your debt unless they co-signed the debt. So just
Okay.
because your spouse passed away, or your sister or your brother passed away, or your parent passed away, it doesn't mean their debt now becomes your debt. It doesn't come under your social security number. You don't have to come out of your personal pocket to pay it, but it still exists. So if let's say Miss Tawana, when she passes away, if she had debt, let's say she had $20,000 at Visa, it still exists. The $20,000 doesn't just get wiped off the book. Let's say I'm her executor, which is the person who manages the will. I now have to call up Visa and say, Miss Tawana has passed away. I see that she has $20,000 of debt. If there's enough in Miss Tawana's estate to pay the debt, then I pay the debt. If I call Visa and say, I know Miss Tawana owes you $20,000, but after I've looked at all of her assets, I only see $6,000 here, then now I need to negotiate with Visa to see if they will accept less than what they are legally owed. And most companies will, because you can't get blood from a rock, or is it water from a rock?
Blood from a turnip, water from a rock, I think,
Okay,
right?
I never know the expressions. I never know the expressions. They can't get what the estate doesn't have. So the job of the executor is to negotiate with the creditor on behalf of the estate. But my job is not to personally pay Miss Tawana's debts. So that's what I mean when I say the debt doesn't go away, but it still needs to be managed. That is the purpose of the will. That's the first basic document that I think everyone should have. The second and the third fall under the category of emergency documents. The first emergency document is the power of attorney. Power of attorney says that I'm alive, but I'm incapacitated. What does that mean? I cannot make decisions for myself. Something is going on in my life where I just can't do the things that I used to do. Dementia, Alzheimer's, mental illness, substance abuse. Something is happening and I cannot participate in my decision-making any longer. So a power of attorney says, if that ever happens, I choose so-and-so, and so-and-so can be anyone. As long as they're over the age of 18 and you trust their ability to step in and make decisions for you, then it can be anyone you choose. So I choose so-and-so to be my agent. The power of attorney means they can make legal decisions and they can make financial decisions. So back to me and Ms. Tawana, she has a power of attorney and she's turned to me and say, hey, Lil, I trust you, you're responsible. If anything ever happens to me, I want you to be able to pay my bills. I want you to be able to sign checks. If I have a business, I want you to keep the business going. I want you to do all the things from a legal and financial perspective that I would do, but I can't do it right now. And I say, okay, got you. So if anything happens to Ms. Tawana, I'm the one paying the bills. I have access to all of her accounts. I have access to her business, assuming she's a business owner. So it's a big deal. This is a very powerful document. You are trusting that that person is going to do the right thing and that they're not going to take monies that are supposed to be used for you for themselves. The good thing is, if you start to feel like this person is not the right person to do this job, you can cancel the power of attorney. So it is a revocable document that you can cancel at any time. So in the example between myself and Ms. Tawana, she's the one who creates the power of attorney. That makes her the principal. I'm the person who she's giving the power to. That makes me the agent. So if at any time the principal doubts the agent's honesty or ability, then the principal can just cancel that power of attorney and name someone else. Here's the other thing to keep in mind about the power of attorney. It's only effective so long as the principal, or in this example, Ms. Tawana, is alive. Once she passes away, I am no longer the agent. My authority has to come from the will. The power of attorney is helping me help Ms. Tawana while she is alive, and the will is helping me help her estate after she's passed away. So they come into power at two very different times in Ms. Tawana's life. And this is important to note because when I opened my firm, one of the first clients that came through the door was a niece. Her aunt had passed away and she thought that she was going to have access to her aunt's CD account. There was money in there that was supposed to be used for the niece to further her master's degree. And she thought that she had that power because she had the power of attorney. She didn't realize that the power of attorney no longer exists once her aunt passed away. So she no longer had access to the CD. You know who did have access to the CD? The executor in her aunt's will. The will was the aunt's daughter-in-law. That daughter-in-law wasn't sharing that money with my client.
Right.
They could have been the best of friends. She could have known that her mother-in-law really wanted the money to go to her niece, but if the niece's name is not on the account and the niece is not the executor in that will, the niece is at the mercy of her aunt's daughter-in-law, and that's how that ended. There was nothing I could do.
Wow,
Because
nothing legally binding,
nothing.
an agreement.
Nothing. So the power of attorney is beautiful. It is powerful. It is revocable, so you can change your mind, but it only lasts so long as the principal is alive. After that, the agent loses their power, and people will do shady things. There's also another person who came through the door who told me, my mom passed away last week and my brother is the agent. And he's trying to quickly sell my mom's house, but he didn't tell the realtor that his mom had died. He was using the power of attorney as if mom was still alive and kicking and saying, oh yeah, I'm the power of attorney. In here, my mom gives me the right to sell the house. So he was trying to sell the house, pocket the cash, and not share it with his siblings. I had to get on the horn and tell the attorney and the real estate person, hey, this person that he's saying that he represents, she died 2 weeks ago. And the sale had to stop. And I'm sure he was not mad. I mean, I'm sure he was not happy. Like, who's Lillie? Who's this Lillie calling people and blowing up my spot? Don't get me involved. Don't get me involved. So yes, the power of attorney is amazing so long as the principal is alive. So that's the first of the emergency documents. The second is the healthcare proxy. Very similar to the power of attorney. The healthcare proxy says, if I'm incapacitated for any reason, then I trust my agent to make medical decisions for me. So power of attorney is for for financial and legal. Healthcare proxy is for health. Okay. Hopefully just the name healthcare proxy lets you know this is for health purposes only. So that means I can have access to Ms. Tawana's medical records where normally HIPAA would not allow me to. I can talk to Ms. Tawana's doctors. I can say, I don't think that treatment is right. I can say, I don't even like this hospital. I don't like this facility. I want to move her somewhere else where I think she will receive better care. So the healthcare proxy allows me to make the medical decisions for Ms. Tawana. The power of attorney allows me to make financial and legal decisions for Ms. Tawana. And then Ms. Tawana's will is giving me the authority to do what she says. With that situation, I'm not coming up with my own ideas. I'm a soldier and I'm taking orders. Ms. Tawana, your will tells me exactly what to do, who's getting the money and all of that stuff. So those are the three basic documents that I think everyone should have. And I just want to pause in case we have any questions.
We've got a few questions and some comments. So Sharnetta says, I love the way Lillie is explaining this and breaking it all down to make it easy to understand. And I agree.
Thank you.
Very, very good. I mean, you're making this as uncomplicated as possible.
Wonderful. Thank you.
I appreciate that as well. We do have a couple of questions. So Kim said, wow, I didn't know the power of attorney is only good while the person is living.
Yes. Now you know, Miss Kim, you're welcome.
And Anonymous says, what's the remedy if you are incapacitated and others around you believe the agent is doing wrong? So you may not think the agent is doing wrong, but others around you do.
Ooh, that is tough. Okay. It depends upon the level of incapacity. If I am incapacitated in the sense like I'm physically disabled, but I'm mentally here, then if I choose you, Ms. Tawana, and everyone around me is like, Lil, Tawana's not doing a good job. If I believe you are doing a good job and I have the mental wherewithal to make that decision, there's nothing anyone can do. This is my power of attorney. I'm the principal and I'm trusting Tawana as my agent. Everybody else around Miss Tawana can say, I think she's stealing from Lillie. But if Lillie doesn't believe it, and I have the mental wherewithal to make those types of decisions, then there's nothing anyone can do. However, if everyone around Miss Tawana believes that she's stealing from me, and I no longer have the capacity, I have dementia, I have Alzheimer's, I'm in a coma, then those persons essentially have to sue me. They have to go to court and say, Your Honor, this person is the agent, but they're stealing from the principal. We have evidence and we think that she should be removed. You can do that. Be prepared for the cost, be prepared for the headache, and be prepared for proof. Lots of people call my office saying, so-and-so is doing this. If you don't have proof, I can't take that case. I can't submit text messages to the judge. I need real evidence. So if the principal is within their right mind and they say my agent is doing a good job, that it is what it is. If the principal is not in his or her right mind, then it's required intervention. It requires intervention of the people around her, and they have to basically sue the agent.
Very interesting. So I know that executors of wills get paid, right? They
can
some
get paid. They can get paid. There are many states have a statutory minimum that an executor can get paid. A lot of times people don't pay their executor because they're doing it for the love, right? Oh, my executor is my husband. My executor is my daughter. And so we just expect our family members to step into those shoes. But me knowing what managing an estate takes, I feel like people should get some type of compensation. They're taking off work, they're filling out applications, they're doing a lot. So if you can give your executor something, that's what I recommend, but 90% of people don't because they're just naming their child or their spouse and no one thinks to pay their family members to do this type of work.
So interesting, because I just learned something. I think because I was one of those people before today that thought about estate planning for the wealthy. So I assumed they were paying the wealthy attorney to handle all of this for them, right? Because my question was going to be, how come there's no compensation for somebody who has the power of attorney? But you just got me all the way together. So really, both of those jobs probably should come with some kind of stipend.
They should. And your power of attorney, you can compensate them if you want. So these are contracts that they're standard, there is standard language, but you can mix it up. Someone has asked me before, I want my power of attorney as long as they're doing work, not when they're just like, I'm not incapacitated and there's nothing to be done. Once I become incapacitated and they start doing work, I had a client say, pay my agent $2,000 a quarter. So $8,000 a year. I've had people say the same thing for healthcare proxies, the same thing for wills. So you can absolutely compensate your person. Or to your point, Ms. Tawana, if you want to hire an attorney, then yes, but I don't have to be the executor. Let's say you didn't hire me as the executor. Let's say you chose Michael. Michael is your executor. Michael calls me and says, I'm the executor of Miss Tawana's will, but I cannot do this. I am so overwhelmed. I have a mom who I'm taking care of. I live out of state. I can't do all of this. Can you handle the responsibilities? And so, yes, I will fill out the paperwork for Michael. I will submit it to the judge. I will be the middle person. I will call the creditors and try to get the debt paid. So it's not that I'm the executor. It's just that Michael has hired me to do his work, but he is still the executor. So that's the job of an attorney during the probate process after someone has passed away. That attorney comes in and says, I see you can't do it all on your own. You can pay me my fee and I'll take care of all of it. But yes, Michael, if he wanted to, he could do it on his own.
Okay.
Yes.
Okay. Very good clarification. We've got a couple of comments in the chat and a couple of questions as well. Kim says, is there still a probate for wills?
Yes. Yes. Great question, Kim. So probate is the process of taking your will to the court, making sure that it's valid, meaning it's original and that the witnesses have signed. The judge looks at it and then gives the executor their letters of executorship. So let's pause there. Just because Ms. Tawana has named me the executor in her will doesn't mean I get to act I don't get to just take Ms. Tawana's will and start doing whatever I need. Let's say I needed to go to Bank of America and close Ms. Tawana's accounts. The will is not enough. That clerk at Bank of America is going to ask me for my letters of executorship. I can only get my letters if I go to the court. So a lot of times people like to avoid probate. I want to put everything in a trust. I don't want to go through probate and all of that. But you need the letters, because unless someone has every single asset tied up in a perfect pink bow, meaning everything has a beneficiary on it, there's no debt, just everything is tight. I've never seen where you don't need the letters, because eventually you need to open an account, close an account. Eventually you need to call a creditor. Even if you need to call the mortgage company to take over the mortgage, they're not having a conversation with you if you don't have your letters. So to your point, Ms. Kim, the will goes through probate. If you don't have a will, then you're still going through the court process. We just call it administration. And speaking of not having a will, if you don't have a will, then the state that you reside in will give you a will. There's rules about what happens to the assets of a person who doesn't have a will. That's called intestate, INTESTATE. That's where the state says, oh, I'm sorry, Ms. Tawana passed away. We don't have a will here for her. So we're going to distribute her assets according to state law. In most states, if you're married and you don't have children, everything goes to your spouse. But they might not know you're estranged from your spouse. I have 2 clients that haven't lived with their spouses for over 12 years. They don't want to go through the getting a divorce. I don't know why. I do try my best to mind my business. So I don't know why they don't just get a divorce, but they don't want to get a divorce and they don't want their person to inherit all of their assets. But the court doesn't know that. The court just knows there's a valid marriage certificate. You're the only closest heir, so everything goes to the spouse. If you have a spouse and children, it's usually split 50-50, 50% spouse, 50% to the children. If you only have children, no spouse, then everything goes to your children. If no spouse and no children, then it likely goes to your parents. It goes up the family tree to parents. If no parents, then back down the family tree to siblings. If no siblings, then further down the family tree to nieces and nephews. So we keep digging for the closest next of kin. And if you're one of those persons, and it's not rare, I had a person come to me with this situation who is the last member of your family. There is no one else to leave your assets to. You didn't put a beneficiary on any of your assets, then your assets now belong to the state. So if you don't have your own will, your state will distribute the assets according to their distribution laws. And if you have no heirs, then your assets now belong to the state in which you reside.
Wow.
Yeah.
That sounds like you want to avoid that one at all costs. Like
For
that
sure.
should never be the default.
Yes.
We need to
Yes.
have something written and
Yes.
documented to avoid that from happening.
Yes. Yes.
If you wanted to leave it to a close friend or the cat,
Yes.
it's better than the state getting it. I mean, goodness
Yes,
gracious.
exactly.
Wow, a lot of great information. Mo said, so Mo was saying, what if the family had proof of the stealing when we were talking
Yes.
about,
If you have proof, Mo, then my job, or the job of the attorney you hire, is to put together a motion and explain the facts of the case and attach any written evidence that you may have. But the attorney also has to gauge whether they think your proof is enough. Sometimes people think, I have the proof. And when the attorney looks at it, because we know the case law, because we know how the judge thinks, we can turn to you and say, I don't think this is proof enough. So proof is subjective, but if you think you have really good proof, bring it to the attorney, let him or her see the proof, and then they can decide if you have a strong enough case to bring it to the judge. But again, be prepared for the time that takes, be prepared for the money that it takes. And in my experience, if you believe someone is stealing from the principal, by the time your case gets to court, they've already stolen everything.
right?
So at that point, you're not stopping them. They've already done it. At that point, you are seeking reimbursement. And the question is, does this person have the money to reimburse what they've stolen? This is not to discourage you from going forward, Mo. I just want you to be prepared for all of the roller coaster, because a lot of times with lawsuits, people get disappointed because it didn't turn out like a Matlock episode. They don't realize that this might take a couple of years. They don't realize that the person has left with the money. They don't realize the person will file for bankruptcy and act like they don't have anything. They don't understand that they might spend $20,000, $30,000 chasing this person around the country or around the state, and then they don't get anything for it. I just want you to be prepared for that.
Very good point. Miss Beulah is questioning the text message. You said, I can't take a text message into court and show the judge, but Miss Beulah's asking, can continuous text messages, will they not hold up? So you see the whole thread, right? I say Michael stole, Michael said, you damn right I did. Like that, is that evidence enough, even though it's a text message?
Yes. Again, back to my earlier point, the attorney will be able to judge if he or she thinks that's enough, and they're writing up the facts in the motion and using the text messages as backup. And then we'd have to prove that the person who sent it is actually the person, like match up the identity of the account holder to the phone number. So there's all of that goes into it, but yes, it can be done. It's just reminding persons that it's not an overnight thing.
Got it. So Beulah says, let's look at Prince. He had siblings outside his immediate family. Does the court go through the process and legitimize them as half brother / sister? And is there a time limit upon which I guess the state has to find someone?
Okay, so great question. I hear two things. The state is not looking for anyone. So when I say that the state distributes the assets, the state doesn't know. I mean, the state knows that Prince died because we all do. But if Prince wasn't Prince, the state doesn't know that John Doe died. Right? So it takes someone connected to John Doe to go to the court and say, John Doe died. He didn't die with a will. These are his heirs. And I want to begin the administration process to manage John Doe's estate. So in Prince's situation, somebody went to the court and said, Prince has died. He doesn't have a will. I'm his next closest of kin, and I want to distribute his assets to his heirs. Now, with respect to half siblings, it depends on the state. In where was he? Was he
Minnesota? Minnesota? I think it was
Okay.
Minnesota, yeah.
I'm not licensed in Minnesota, so I'm not going to pretend to know the law, but perhaps Minnesota has a rule whereby as long as you can prove that someone is a half relative of the decedent, then that's enough to receive their assets. So in Prince's situation, his half siblings are still going to be considered his siblings. The whole half thing really comes into play when you have a parent who's passed away and you need to prove that the child not born in the marriage is actually a child of the person. That becomes a little bit more complex. But when we're dealing with siblings, the fact that you share one parent in common makes you a sibling in the eyes of the law and makes you entitled to that person's estate if they didn't have a will saying otherwise.
Okay, that actually was going to be my follow-up question, the whole concept of half. I was wondering, do states have laws that define that? Because in my mind, a sibling is a sibling, right?
Right,
and so,
right.
I'm happy to see the law agrees because,
Yes,
because how do you determine half, right? Because if we share a mother, are we more half than if we only share a father?
Right. That's why, most states are beyond half sibling, but a lot of states are still caught up on the concept of legitimate and illegitimate children. That the courts are still holding strict to. So someone needs to prove, yes, this is so-and-so's son, but the son didn't come from the marriage. The son came from somewhere else, but I can prove it because there's a birth certificate with dad's name on it. It usually comes up in the context of men. So that is when it becomes more challenging.
Very good.
Yes.
So we know we need a will. We need our power of attorney. We need our healthcare proxy.
Yes.
Are there any additional emergency documents that we need to be mindful of?
No, I will say that those three are the basic that I think everyone should have, regardless of wealth, regardless of anything. A lot of times, again, people discount themselves because they say, I'm not wealthy. I don't have real estate. What's the other reason? I'm not married. I don't have children. But I always tell persons, if you have an asset and you care about where it goes, it can be a co-op, it can be a piece of land, it can be all of your retirement money that you've accumulated. You should still have a plan around it. Don't discount yourself because you don't have the traditional family and you're not considered wealthy by today's standards. Still have a plan around the assets and the people who are important to you. And I will add this. Let's talk about what I call the planning pyramid. A planning pyramid means, imagine the literal pyramids where you have the top or the apex, the center, and the bottom or the foundation. The top of the planning pyramid is called operation of law. There are assets that we know where they go because there's a law that dictates where it goes. For instance, real estate, the title on a real estate, that is a legal document. The title will tell you who owns that property after one person passes away. So let's say Miss Tawana and I own a rental property together, and the title says between Lillie and Tawana jointly with rights of survivorship. That means when Miss Tawana passes away, Lillie becomes the 100% owner automatically. No ifs, ands, or buts. I don't need to go to court. I don't need a will. And vice versa. If I pass away first, Miss Tawana is the 100% owner, no ifs, ands, or buts. Miss Tawana can have her will that says, my house on 100 Main Street, I want it to go to Michael. But because we're dealing with operation of law and it's at the top of the pyramid, it trumps the will.
Interesting. So I can't even leave Michael my portion
No.
of it.
No,
Interesting.
because jointly with rights of survivorship means there is no portion.
Okay.
We both own it 100%. Now, there is a different title called tenants in common, or TIC. Tenants in common means you own 50% and I own 50%. So you can leave your 50% to Michael. So when you pass away, all of a sudden, me and Michael co-own this property. I may or may not like that. I might want to buy him out. I don't know. I have to figure that out. But if it's jointly with the rights of survivorship, we both own it 100%. There's nothing for you to leave anyone. And so that has come up. The will says one thing, the title says something else, and I have to break the news to people and say, the title is the title, but I've been living here and she promised me and I've been paying all the utilities. Paying the mortgage, paying the property taxes, fixing the roof does not mean you are an owner. If your name is not on that,
on that deed or title, yeah, you're just a house guest.
You are a very welcome house guest because we love to see you paying all of these bills, but you own nothing here. So that's the top of the pyramid, operation of law. The middle is operation of contract. Anything with a beneficiary is a contract. Okay. IRAs, 401k, your pension plan, your life insurance. You can go down to your local bank and put a beneficiary on your checking and your savings accounts. That means when you pass away or when the owner passes away, because there's a beneficiary, that money goes directly to that beneficiary. No ifs, ands, or buts. I had a gentleman call me, and it was really a sad situation. His wife had recently passed away. They had 2 minor children, and he was saying that he found out that she, on her 401k, she had her ex-boyfriend listed as the beneficiary. This woman forgot to remove the ex-boyfriend's name and put the, I don't know if she forgot. Like I said, I do my best to mind my business. So at the end of the day, she did not remove her ex-boyfriend from the beneficiary. And her husband is like, I'm here, I'm taking care of our children. I should get it. And I'm saying you should, but you won't, because the contract trumps the fact that you're married. Now, if ex-boyfriend wants to share the money with you, but I've never seen anybody share money, ever.
Really?
Get rid of that idea. When people smell money, especially found money, you won't believe how entitled people become when they get found money. Like, I didn't even know my aunt left me $20,000. Now they're ready to fight everybody for the money that they weren't even expecting. So this boyfriend got this 401k money. it takes a special kind of sweet person to say, I'm going to give you this money, or I'm going to share a portion of the money with you. So that husband did not see that money. So operation of contract is the middle. So I always encourage persons, remember at the top of this call, I said, there are things that you can do that have nothing to do with me. You don't need to hire me or anyone. Adding and making sure you have the right beneficiaries on your contracts is a form of estate planning. Make sure that if someone has passed away, take their name off of it. If you found out that someone is not good with money, take their name off of it. If someone has a disability, they have a special needs and they're receiving government benefits, take their name off of it, because you are going to disqualify them from their government benefits. Because the government is only giving them money because they look poor. If they find out auntie has left you $50,000 in her IRA, you're no longer poor. We're going to take away those benefits and give it to someone else who's in greater financial need. So don't name minors as beneficiaries. Don't name persons who have a special need and are receiving government benefits as a beneficiary. Someone is dead, remove their name. You don't even like someone anymore, remove their name. You're divorced, remove their name. These are all things that you can do. Your checking and savings account, add a beneficiary. When you pass away, those accounts get locked up. Remember when I spoke about the letters of executorship, that you need that in order to do all the legal work? The letters of executorship, because your accounts get locked up, no one can access your checking account or your savings account until the letters come from the court. But in the meantime, mortgage needs to be paid. The daycare needs to be paid. The car note needs to be paid. The funeral expenses need to be paid. So if you can add someone as a beneficiary to your checking account, that means they can go into it, not while you're alive, because they're not a co-owner. They can only get into it after you've passed away. So naming them as a beneficiary means they can go in there and say, oh my gosh, my mom has $8,000 here. That's enough to pay for some burial expenses. That's enough to pay the mortgage for the next few years while we figure things out. That is a huge relief versus having to go through the court process first, get the letters first, and then going to the bank and saying, can I now have access to the money that's been sitting in my mom's account for probably a year or so at this point. So operation of contract means there's a beneficiary listed, and then the foundation refers to your estate planning documents. So think of your estate planning documents that control the assets that do not know where to go. Okay. If it passes by operation of law, I know where that asset goes. Same for operation of contract, but everything else is just hanging out. What do I do with the car in the driveway? What do I do with the art? What do I do with the checking and savings account? What do I do with the minor children? There's this big expectation that auntie and godmom and grandma will step in, best friend will step in. That's a huge responsibility to take on a child and move them into your home and now treat them as your own and come up with the extra money to raise them. So you should be making provisions in your will to take care of these minor children. So your will and all the other types of documents, such as a trust, which we can get into, are the documents that control the assets that do not know where to go. So that's the planning pyramid. So go and look at your beneficiary designations, go and look at the deed and the titles on your property, because that will solve many, many headaches in the future. And you can do both of those things without an attorney.
Okay.
Yeah.
It's a lot to think about. I mean, yes. It really, and a lot to do once you think about it. It's like, it's a lot to do.
Yes.
So, Ms. Opal asked a wonderful question. As you know, we're an investor community, right? So we invest in non-traditional assets, and we also invest in equity of Black founders, right? So Black entrepreneurs. And so Opal's asking, are the business investments that we make here at the 10K Project eligible to be added to our wills or an estate as an asset? And absolutely, it would be, right?
Absolutely. So you can manage that in two ways. You can have a will which says, I invested in ABC company and I own shares or I own something related to that investment. And now I want Michael or Tiffany or Lily to be the new owner of that investment, to be the new owner of that asset. Or you can say, I don't want to give it to Michael or Tiffany or Lillie directly. I want to hold it in trust. So this is another question that comes up. What's the difference between the will and the trust? The will is quick and dirty. Again, my name is Tawana. This is my family, pay my debt, whatever's left, give it to the beneficiaries. We're done here. You want to close that estate as quickly as possible. The trust says, I do want my beneficiaries to receive this money, but not all at once and not immediately. I want them to graduate. I want the money to be used for investment. I want the money to buy a rental property. I have these rules and parameters and restrictions around the gift that I'm leaving behind. If that's you, then the trust is the document to use, because the trust can last for a very, very long time. Here in New York, it lasts for 21 years after the last beneficiary passes away. So if the last beneficiary is 80, this trust is lasting for 80 plus 21 years. Roughly, right? So this is the trust, this is the document that you use when you say, yes, Lily's going to receive the $20,000, but only after she graduates. Or she's going to receive the $20,000, but not all at once. She will get $5,000 every year for 4 years. So to the question regarding investments, if you're saying, I want Lillie to get the investment, but I want to hold it in trust, and then she can get the income from that investment without having to own the investment, then you can look towards the trust to fulfill that desire. But if you want Lillie or whomever the beneficiary is to just receive that investment all at once, then you can leave it to them in a will.
I love everything about this, because that trust is that document that keeps them from going out and buying the car and the jewelry and every Gucci bag, right? That the trust is what keeps them wealthy, right? If you left wealth. I mean, it is the thing that controls that instant gratification when we get money, sometimes burning a hole in our pocket, right? That's going to be the thing that prevents them from just abusing it. So that is absolutely wonderful.
Wonderful.
Chasma says, what's needed to access the beneficiary funds if named? So there's a beneficiary. What is needed? Is it just the death certificate, or is it something else that's needed?
Are you talking about if you name someone the beneficiary of an account?
Yeah, like
yes. So you need an original death certificate. So if I am the beneficiary of Ms. Tawana's 401k, then I am presenting a valid copy of my ID, as well as an original death certificate. That's why I always encourage persons, when someone passes away, don't just take the 2 or 3 death certificates the funeral home gets you. Order more. Get 10, get 15. They're not expenses relative, so I won't say they're not expensive, but get 10 or 15, because if you have to interact with Bank of America and Chase and the 401 company and the BMW lease company, they're all going to want original death certificates. You can't just photocopy this. So be prepared to just give death certificates to these various institutions. So order a lot. But yes, all I need is a valid ID showing that I am who I am. And I need a death certificate showing that Miss Tawana has passed away.
Okay. Also another question from Chasma, where are you licensed to practice?
Oh, great question. So I'm in 5 states. I'm in New York, New Jersey, DC, Maryland, Georgia. New York, New Jersey, DC, Maryland, Georgia. I have connections. I have a running list of estate planning attorneys across the country. So if I'm not licensed in your state, you can still send me an email and I might be able to connect you with someone. If I don't know someone, then go to your local bar association, go to the estate planning section. Some call it wills section, some call it probate section. Some people call it trust and estate section. And there you'll be able to find local attorneys broken down by county, assuming those bar organizations are organized.
Right, right.
Yes.
So very good. And go ahead and, if you don't mind, putting your contact information in the chat so that the community members that are in New York, New Jersey, DC, Maryland, or Georgia can reach out, because I'm sure they're gonna have some additional burning questions and gonna want to need your help.
Wonderful. I just put the website, which is my first and last name.com. You can schedule a consultation. I think my email is there. If my email is not there, let me type it in the chat right now. And then we can come to Massachusetts. I'm actually from Providence, Rhode Island, but I have no desire to go back up there. So, but I know someone. So let me know if you need a Massachusetts attorney. I can connect you with this lovely young estate planning attorney who works at a firm.
Nice. Denise says, what's the living trust? She said, is that the same as an irrevocable trust?
Great question. So living trust, family trust, revocable trust are all the same. These are documents, these are trusts that you can create and change at any time. You can change the terms, you can add people, you can remove people, you can add assets, you can remove assets. It's very flexible. I use this trust for the person who has a young family and things are still changing, or they are young themselves and things are still changing. They don't have any issues with creditors. They don't fear being sued, and they're not wealthy yet. And wealthy varies by state. That way they can have control over everything, because the revocable trust means it still really belongs to me. And so if there's income in there, I'm being taxed. When I die, whatever's in the trust is still part of my estate. So that's the revocable trust. Irrevocable means I am putting an asset in this trust and I'm wiping my hands of it. I can't go in there and control it. I can't take it out. I can't change the terms. It's a set it and forget it document. The irrevocable trust is good for people who are wealthy, because if I put something in an irrevocable trust, I've removed it from my name. So when I pass away and the government is trying to figure out if I owe estate taxes, they cannot count the assets that are in an irrevocable trust. So if you are wealthy, and for instance, New York defines wealthy as a person who has more than $6.5 million in assets per person. If I am a single person and I'm worth more than that, or I'm getting close to it, I'm going to start tucking assets in the irrevocable trust so that when I die, those assets aren't part of the value of my estate. So let's say I'm worth 10 million. If I tuck 5 million into an irrevocable trust, in the eyes of the IRS, I'm now worth 5 million. But that's not the same with the revocable. That revocable and I are the same person. We have the same tax ID number. The tax ID number for the revocable is my social. So I can move things all I want. In the eyes of the IRS, I really haven't moved anything. I've just moved it from one pocket to the other, but it's still in the same pair of pants. So irrevocable is different from living trust in that the irrevocable is set it and forget it for people who are wealthy, in my opinion, and people who are likely to get sued. Architects, general contractors, OBGYN, those persons get sued a lot, right? If you're not in that situation, I would lean towards the revocable because it's flexible and you can make changes, and it just goes a long way. You don't have to set it and forget it.
So you just said something that made me think. So like when you set up a business, right, a corporation or an LLC, it's always good to have an attorney and an accountant kind of consult, right? So that together they can help you come up with the best plan. Is it the same way when you're setting up these trusts? Because I'm thinking there are some, you mentioned the IRS, I'm thinking there are also tax implications, right?
Right.
10 million versus 5 million, right?
Yes.
And on inheritances and all of that stuff. So is this really a conversation where you bring your attorney and your accountant kind of to the table as we're setting this up? Or do you work with an accountant in your office that kind of helps answer some questions that your clients may have from a tax perspective?
Yes. So the will, there are lots of online software programs where you can go in and kind of whip up a will. And my preference, and I'm sure you're going to say I'm biased because I'm an attorney, my preference is that you do your estate plan with an attorney. Why? The software programs assume you know what you're doing. They assume that you checked the right box. They assume that when you say, I want all of my money to go to my daughter, that you really mean that you don't mean to hold it back and give it to her little by little. So there's a lot of user error in my professional opinion. But if time is of the essence and money is really, really tight, then I can understand someone going online and getting one of those software produced wills. I would never do that for a trust. I don't even know if this, I can't say that they don't offer it. I would personally never do that for a trust because it is so much more complicated than most persons will. So again, I think you should use an estate planning attorney for both documents, but if you really need to hurry up and we're engaging in deathbed planning, which comes up, oh, my dad's in the hospital, we're freaking out, we need to go get a will, then I suppose, yes, go online, do the best you can and get it done, but don't do that with a trust. That's my professional opinion. And as far as tax liability and things of that nature, once I'm dealing with someone who's wealthy and has those moving parts, I'm suggesting that they have a CPA so I can have a conversation with him or her. Or if they don't have one, I'm giving them a list of 3 that I know, and I want them to go choose the person that they like the most. To me, it doesn't matter whom they choose because I think they're all competent. If I'm giving you a referral, I think this person is competent. So come to the table with your CPA, or I can recommend a CPA if we're dealing with tax liability issues as it relates to your planning.
Okay, and Atia asked a question, but I'm gonna change her question around a little bit because I feel like you answered her question. But Atia's question was that there are will templates, and you just went over that. She asked, can individuals fill out those templates and get them notarized? Will that suffice? But I want to ask a different question. What if I don't have a will template? What if I write a detailed letter of my wishes and have it notarized? Is that a legal document that can hold up in court?
It depends on the state you live in. It's not legal in New York.
Okay.
I don't know if everyone's been paying attention to the estate of Aretha Franklin. They finally, 5 years later, came to a resolution. She had handwritten wills.
She had it in the couch or something, right? Did she have it under the sofa or in the sofa?
Yes. So she had 2. The problem with her is not that she had a handwritten will, because in the state in which she lived, handwritten wills are allowed. She just had 2 handwritten wills that said different things. And we couldn't figure out which one was the real will to be probated. That's what's been taking 5 years to get that settled. So it depends on your state. It's called a holographic, HOLO graphic. Holographic will or handwritten will. You can do a quick Google search, whatever state you're in. Does California recognize handwritten wills? Does Kentucky recognize handwritten wills? And you'll see what they say about it. There are surprisingly a lot of states that do allow handwritten wills. It's not my favorite because it's not thorough, but if your state allows it and you are sick and something's happening, it can be used.
Okay. So in Atia's question, the will template that she uses, does that have to be notarized? Or if you use it in the software, is it automatically notarized as part of the software, or it just prints it off and you still have to get it notarized?
It's not automatically notarized, and your state determines if notaries are necessary. In New York, notaries are necessary for wills. There are other states that just need you to sign and 2 witnesses to sign. Okay. And that's all you need. The 2 witnesses have to be disinterested, though, meaning they can't benefit from the will. So if you're leaving everything to your son, then he can't be a witness as well. But I could be a witness because you're not leaving anything to me. So you would have to look up your state's rules. Most do want a notary attached, but then there are also a lot that says as long as it's signed and witnessed, it's fine.
This has been absolutely wonderful. I'm going to end this with Denise's question because we're over the hour, and I apologize for that, but this information has been amazing.
Wonderful.
And I agree, it's been told to us in a way that we are going to remember the scenarios you use. Good. And we feel like we're going to walk away knowing exactly what we need to do next. So thank you so much for that.
So welcome.
But Denise's question is, what's the typical cost to have an estate planning attorney? What's the average charge that we could expect?
That's a good question. It depends, which is the perfect lawyer answer. A smaller boutique firm that has maybe 1, 2, or 3 will be less than, your high-rise law firm on the 30th floor in downtown, Manhattan. I have seen wills range from $1,500 to $2,500. I have seen trusts range from 2,500 to 4,500, depending upon the complexity. The more complex it gets, the more intense it gets. And then you have to determine if you're working with an attorney who's doing a flat fee or someone who's hourly. So when I say 1,500 to 2,500, that captures the flat fee attorney and the hourly attorney. So even if I bill hourly, which I do, if it takes me 4 hours to do your document, that's 2,000, right? Or 1,700, depending upon what I'm billing. Or even if I do a flat rate, that's what it is. So wills will range anywhere between 1,500 and 2,500. A trust will be more. A really complicated trust will be even more. And if you are wealthy, meaning you exceed the threshold in your state or the federal government, then you're going to have a lot more moving parts, and it's going to be even more wealthy, more money.
Yeah. Lillie, this has been absolutely wonderful.
Wonderful.
Thank you so much.
You're welcome.
This is, you don't know how helpful and timely this is, just for me personally. So this is very, very helpful. Tracy is in the participants list, and she's been telling me I needed to get some of my stuff in order the last 6 months. And so now, she's been texting me the whole time you've been talking, like, I told you we need to get.
Go ahead, Miss Tracy, stay on top of her. We need good friends and family who stay on top of us to do the things.
Absolutely do. And I am blessed with all of those things.
Good.
This has been wonderful. You have definitely blessed us this evening. I think a lot of estates are going to be saved because you've given us some good information here. So guys, I always kind of end these with, we've been given the information. What we do now is on us, right? And what we don't do now is on us. So thank you guys for coming and listening. Lillie, thank you. I'm sure all our New Yorkers, New Jersey people, DC, Maryland, and Georgia, they're gonna be hitting you up, girl. So get ready.
Please do. And follow us on social media or LinkedIn, because I do release videos with this information, and I'm going to start doing more, because it can be hard to kind of work and then also pause to do a video to put on Instagram. It's like, but I'm going to do a better job, and you'll see information there. So you can follow up there and see videos. And there was a whole series where I broke down each document and things of that nature. So if you need a refresher, it's there, and it's on my website as well.
Wonderful. We're going to put this replay in our newsletter that we send weekly to the community. And so we'll be sure to add your social handles there so they can easily find you as well.
Wonderful.
Thank you so very much.
You're so welcome. Thank you, everyone. I hope this was helpful.
Have a wonderful evening, everyone.
Bye.
Bye.